Good morning from a cold and wet Greyton. Just a few words from the prophet Isaiah, chapter 59. Justice is turned back, and righteousness stands far away. For truth has stumbled in the public squares, and uprightness cannot enter. Truth is lacking, and he who departs from evil makes himself a prey. I've been reflecting on the measures that the Constitutional Court have been going to ensure that Mr. Zuma has an opportunity to put his case before they make a finding or ruling as regards whether or not he's guilty of contempt of court and what an appropriate sentence would be. Now, most folk are outraged at this, what seems to them a far too cautious approach, and not treating Mr. Zuma like any other person would be treated. But as a lawyer, and a lawyer who really believes in the right to defend oneself and the right to put one's case, I fully understand the caution of the Constitutional Court. They have to get it right. They have to make sure that Mr. Zuma has had an adequate opportunity to put his case before they get to make a decision about him. My problem, however, with the Constitutional Court, and this deals with these verses from Isaiah where we read about the absence of truth from the public square, and nowhere there's no more important institution in the public square in South Africa when it comes to truth than the Constitutional Court. My problem with the Constitutional Court is its hypocrisy and its complete lack of consistency, and indeed its cowardness when it comes to who it gives the right to defend itself and who it doesn't. Mr. Zuma is a high profile, the stakes are high, so they bend over backwards to make sure they get it right with Mr. Zuma. However, when they were confronted with the plight of, over the years, literally millions of unborn babies who turned to the Constitutional Court and pleaded with them to come to their defense, to give them a right to be heard before a decision is taken, simply to kill them at the behest of their mothers by nurses or doctors. When that was put to the Constitutional Court, the only response from the Constitutional Court was one line, with no reasons for the one line. And the effect of the one line was that they are not prepared to give unborn children an opportunity to put their case as to why their life and their dignity should be protected. This also is in stark contrast to, for example, perhaps the most famous of the constitutional cases, or certainly one of the most famous, the one that dealt with the abolition of the death penalty in the mid-90s. Yeah, the person concerned was a vicious convicted murderer. And yet if you read that judgment, the same court bent over backwards to make sure that this vicious, cruel convicted murderer was given a hearing so that his dignity and his right to life could be put before them before they made a decision about whether or not he should be executed or not. It's a long judgment, that one. It's over 100 pages. In the unborn child matter, one sentence, without giving any explanation, effectively saying they have no right to put their case as to why their right to life, their dignity, should be protected. If you're interested in the full details of that matter, you can find it in a book I've written, The Emperor Has No Clothing, the Emperor being the Constitutional Court, and that's freely available on my website, keithmathee.com, and you can then simply download it at no cost to yourself. Thank you.